How can seniors protect their assets from probate? Imagine leaving behind a legacy that goes straight to your loved ones without the hassle of court delays or extra costs. That's what protecting assets from probate can do for you. Probate is the legal process that distributes a person's estate after they pass away, but it can take months or even years. It can also eat up a big chunk of your estate in legal fees and taxes. For seniors planning for the future, finding ways to avoid probate helps keep more of their savings intact for long-term care and financial security. One popular method is setting up a revocable living trust. This is a legal document where you transfer ownership of your assets into the trust while you're alive. You stay in control as the trustee and can change the trust whenever you want. When you pass away, the assets in the trust go directly to your beneficiaries without going through probate. It's a simple way to keep things private and save time. You can also add provisions to protect against financial exploitation by naming co-trustees or successor trustees who manage your assets if you become unable to do so. Another option is an irrevocable trust. And like the revocable type, once you transfer assets into an irrevocable trust, you cannot change or take them back. This removes the assets from your ownership permanently, helping protect them from probate, lawsuits, and even from Medicaid estate recovery. Seniors often use these trusts to shield assets while also reducing the countable assets needed for Medicaid eligibility. Medicaid asset protection trusts are a specific kind of irrevocable trust designed to help seniors qualify for Medicaid long-term care benefits. When you transfer assets into a Medicaid asset protection trust, they are not counted as part of your estate after a 5-year look-back period. This helps preserve savings for future care while meeting Medicaid's rules. You can also consider life estates, which involve dividing ownership of real estate like your home. You retain the right to live in the house for life, but the remainder interest passes to a beneficiary when you die. This transfer removes the property from probate and can help protect it from Medicaid estate recovery. Joint ownership with rights of survivorship is another way. If you own property jointly with a spouse or adult child, it automatically passes to the survivor without probate. Just be aware that this method can have tax implications or expose your property to creditors. Gifting assets to family members before you pass is another strategy. You can give away property or money, but you must consider Medicaid's 5-year look-back period. Gifting too close to your death can lead to penalties or disqualification for benefits. Beneficiary designations on retirement accounts, life insurance policies, and payable on death bank accounts also help. These assets transfer directly to the named individuals without going through probate, making the process quick and simple. Avoiding probate saves time and money, as probate can take months and cost up to 20% of your estate in fees. It's important to follow legal rules, especially with Medicaid, which scrutinizes asset transfers made within 5 years of applying for benefits. Consulting an elder law attorney is highly recommended. They can help you create a plan that protects your savings, complies with the law, and aligns with your long-term care goals. Proper asset segregation and regular reviews of your estate plan ensure everything stays current and effective. In summary, seniors can protect their assets from probate by using trusts, life estates, joint ownership, gifting, and beneficiary designations. These strategies help preserve savings for future care and reduce the financial burden on loved ones. Proper planning ensures your legacy is secure and your financial future remains stable.